The judgment and opinion of the court in 72-671 Espinoza against Farah Manufacturing Company will be announced by Mr. Justice Marshall.
This case is here on writ of certiorari to the Fifth Circuit. This case involves the interpretation of the phrase, quote, national origin, end quote, in Title VII of the Civil Rights Act of 1964. Mrs. Espinoza, a citizen of Mexico who resides in San Antonio, was refused employment by Farah Manufacturing Company because she is not a United States citizen. We hold today that an employer's refusal to hire a person because he or she is not a United States citizen does not, standing by itself, constitute employment discrimination on the basis of the quoted words national origin. We reached this holding relying for the most part on the clear indication that Congress did not intend the term national origin to embrace citizenship requirements. 2 points deserve emphasis. First, the question presented is not whether Congress has the power to prohibit private discrimination because of alienage, nor whether Congress itself can discriminate against non-citizens in federal employment. The question is not what Congress can do or should do, but what Congress did in Title VII of the Civil Rights Act. Second, the record in this case conclusively shows that Farah did not discriminate against persons of Mexican national origin. In fact, 96% of Farah's employees are of Mexican national origin, as was the individual hired in Mrs. Espinoza's place. The company's policy, and now holding, is limited to a citizenship requirement, which is applied in an ethnically neutral manner, barring employment of a blue-eyed, blonde-haired citizen of Sweden, a black-skinned citizen of Nigeria, or a Spanish-speaking citizen of Mexico. Discrimination against persons of Mexican national origin, like discrimination against women or Negroes, is also forbidden under Title VII. But nothing in Title VII was intended to prohibit an employer from applying a racially neutral and ethnically neutral requirement of United States citizenship.
Thank you, Mr. Justice Marshall. The judgment and opinion of the court in 72-331, Lefkowitz against Turley, will be announced by Mr. Justice White.
In this case, the district court for the Western District of New York held invalid certain New York statutes, the effect of which was that architects furnishing services to the state under contract would either waive their privilege against compelled self-determination and answer questions before the grand jury, or forfeit their contracts and be disqualified from contracting with the state for a period of years. We affirm the judgment of the district court. Our previous cases dealing with the 5th and 14th Amendments clearly control this one. The architects involved here surely may be required to answer questions about the contracts they are performing or that they have performed in the past, but they may not be deprived of the privilege against compelled self-determination guaranteed to them by the 14th Amendment. Hence, if answers before a grand jury are to be required, the state must recognize that the architects are entitled to the immunity that this court has held as necessary to supplant the protections of privilege. The judge of district court has affirmed. Mr. Justice Brennan, Mr. Justice Douglas, Mr. Justice Marshall has filed a separate statement joining the opinion of the court in all important respects in the same way.
Thank you, Mr. Justice White. The judgment and opinion of the court in Number 71-1631, Kusper against Pontikes, will be announced by Mr. Justice Stewart.
Before I announce that opinion, I think Mr. Justice Marshall has something to add.
In the case I announced, 671 Espinoza against Farah, Mr. Justice Douglas has filed a dissenting opinion.
The opinion I am authorized to announce this morning is in number 71-1631. Stanley T. Cusper, Jr. and others, appellants against Harriet G. Pontikes, appellee, in a case which is here on appeal from the United States District Court for the Northern District of Illinois. Under a provision of the Illinois Election Code, a person is prohibited from voting in a primary election of a political party if he has voted in the primary of any other party within the preceding 23 months. The appellee, Harriet G. Pontikes, is a qualified Chicago voter who voted in a Republican primary in February of 1971. She wanted to vote in a March 1972 Democratic primary, but was barred from doing so by this 23-month rule. She filed a complaint for declaratory and injunctive relief in the United States District Court for the Northern District of Illinois, alleging that the Illinois law unconstitutionally abridged her freedom to associate with the political party of her choice by depriving her of the opportunity to vote in the Democratic primary. A statutory three-judge court was convened, and that court held, one judge dissenting, that the 23-month rule is unconstitutional. We noted probable jurisdiction of this appeal from that judgment. For the reasons set out in some detail in the written opinion filed today, we conclude that this provision of the Illinois Election Code unconstitutionally infringes upon the right of free political association protected by the First and 14th Amendments. The judgment of the District Court is accordingly affirmed. The Chief Justice concurs in the result, and I am authorized to say that Mr. Justice Blackmun has filed a dissenting opinion, and that Mr. Justice Rehnquist has also filed a dissenting opinion in which Mr. Justice Blackmun has joined.
Thank you, Mr. Justice Stewart. The judgment and opinions of the court in number 72-481, Department of Game of Washington against Puyallup Tribe, and 72-746, Puyallup Tribe against the Department of Game, will be announced by Mr. Justice Douglas.
These cases were here before and involved the construction of a treaty with the Indians of the Puyallup Tribe, which we held previously in the prior decision, covered commercial fishing by nets. And we remanded the case when the cases were here before for reconsideration by the Washington Supreme Court, reconciling the treaty right to fish by nets and the right to fish by hook and line with the conservation standards that we emphasize exist in when the cases were here before. On the remand, the Supreme Court of Washington, on consideration of the conservation issue, restricted all steelhead fishing in this particular river, the Puyallup River, to fishing by hook and line. We hold that is not consistent with the treaty rights of the Indians. The commercial fishing by nets raises considerable problems in connection with the conservation problems. But we must remand the case, we feel, to the Supreme Court of the state of Washington so that some equitable solution consistent with the treaty rights can be worked out. Our views are elaborated in an opinion filed with the clerk. Mr. Justice White has, while concurring in the opinion, has filed a separate opinion in which the Chief Justice and Mr. Justice Stewart concur.
Thank you, Mr. Justice Douglas. I have the opinion of the court and judgment to announce in number 72-922, Paschall against Christie-Stewart Incorporated. And for reasons stated in an opinion filed this morning, the judgment of the Supreme Court of Oklahoma is vacated and remanded for further consideration. I'm authorized to state that Mr. Justice Douglas, with whom Mr. Justice Stewart joins, filed a dissenting opinion.